All right, well, my name's Arthur Southard, and welcome to this presentation of You in the Legal System. And today we're going to focus on bankruptcy and how it relates to garnishments, and also about helping people save their homes by using bankruptcy. So a little bit about myself. I'm a solo practitioner. I've been practicing on my own for over 5 years. My main area of practice is bankruptcy, but I do some civil and criminal defense work as well. The presentation today, just kind of as a disclaimer, there's no legal representation between us that's going to be formed by this presentation. And the way I'm kind of going to proceed with it is kind of just give some background on the different types of bankruptcies, and then kind of dive into wage garnishments, and then I think the home ownership issue and mortgages, and then what I'd like to do is kind of turn it back to the audience here so that they could have time to ask me questions. So I hope that that's probably going to be the majority of our time together, is just kind of fielding questions, and I'll do my best to kind of answer them and maybe use some hypotheticals that you may have in mind. Okay, so to kind of begin. There's kind of two main types of bankruptcies that individuals file. It's Chapter 7 and Chapter 13. Chapter 7 is called the basically fresh start bankruptcy or total liquidation bankruptcy. It'll wipe out most types of debts except for student loans, generally taxes that were incurred within 3 years. It won't wipe out those. It won't wipe out any debts incurred by fraud, any court-ordered or criminal restitution like traffic tickets or restitution ordered by a judge criminally in obviously a criminal case. It won't get rid of any domestic support obligations. So that would include child support or spousal support. Won't get rid of those. So those are kind of the general areas that it can't get rid of. And one last thing is personal injury caused by driving under the influence of drugs or alcohol. If someone gets a judgment against somebody and they file bankruptcy, they can't get rid of that judgment from that civil case if they were under the influence of drugs or alcohol when they injured somebody, they injured the plaintiff. Okay, so Chapter 7 is a good option to kind of give somebody a fresh start. And you have the timeline there. There's two timelines, one for 7 and 13. The background on the 7 is once the case is filed, there's an automatic stay that goes into effect that will stop any sort of legal proceeding against the person who's filed bankruptcy. The person who's filed bankruptcy is called a debtor. The person who is coming after them for money or on old debts is called a creditor. So the creditor cannot pursue the debtor legally because the automatic stay protects them. It's pretty powerful. It'll stop the mortgage company from sending someone mortgage statements. It'll stop a lawsuit. If the case were to be filed today and the next day there was a sheriff's sale downstairs here on the second floor of the Hamilton County Courthouse, you could contact the sheriff's office, contact the creditor's attorney in the foreclosure, and they'd have to stop the sale. So it's a very powerful law, and it's part of the reason to file is to stop these sort of collection attempts and lawsuits. So that's very important. Once the case is filed, all of the debtor's property goes into what's called a bankruptcy estate. Bankruptcy estate's administered by a trustee. There's a trustee that's appointed to the case. Within 30 to 45 days after the case is filed, there'll be what's called a first meeting of creditors, or a Bankruptcy Code Section 341 meeting of creditors. The trustee is there. The debtor has to attend it. Creditors can attend it. The debtor is sworn in by the trustee. There's not a judge there. It's not in a courtroom. The trustee swears the debtor in and asks the debtor questions about his or her finances. Creditors can ask the debtor questions about the debt, if there's an insurance on their property. They can basically ask questions about the person's finances. Those occur about 30 to 45 days after the case is filed. From there, if the case goes well, there's what's called, I think the most important thing, even more important than the automatic stay, is called the discharge order that's entered by the court. And that's important because that's the order that discharges or wipes clean the debts. So you stop the collections at the beginning, and then at the end, possibly usually about maybe 4 to 6 months after the case is filed, the debtor gets a discharge order from the bankruptcy court wiping out the debts that are dischargeable. And we kind of went through earlier the list of debts that are not dischargeable, right? So the student loans, court-ordered criminal restitution, domestic service obligations, et cetera, et cetera. So that's kind of Chapter 7 in a nutshell, and in order to qualify for it, you look at the debtor's past 6 months of income, and it's kind of a means test analysis based off of the number of people living in the debtor's household, or who the debtor's providing support to. Okay, that's one half of qualifying. The other half of qualifying, and to kind of break it down or make it as simple as possible, is basically, hey, is this person filing the case in good faith? Can they afford to pay anything back to their creditors? Okay, so that's kind of the basic way people qualify for bankruptcy, whether it's a 7 or a 13. It's just the means test affects them differently.
Can I ask a question now?
Yeah, go ahead. Yeah.
Should I wait till the end?
No, dive right in. I kind of wanted to be totally open with that.
If there were more people in here, I would wait, but I'm afraid I'll forget. So
Yeah.
when you meet as a group, your creditor and you're the debtor, and the creditors meet you say you meet.
Mm-hmm.
Can you at that point, can someone say, refuse you to file? Refuse that you're able to file? Could your creditors say to your trustees and you, while you're sitting there, no, we don't think this is a good thing?
I mean, I guess theoretically they could say that, but I think what it's about is determining whether or not maybe there's insurance on a piece of property, or ask, if there's a debt that's secured by a ring, someone used a credit card to buy a ring at a jewelry store, they might want to know, hey, where's that $20,000 ring you bought?
Right,
did you pawn it? Where is it at? Because we have a security interest in it and we want to recover it, and you don't want to keep paying us. So there's different things that they can ask. I would say the vast majority of the time, the creditors do not show up to it. If there's an issue, if they're disputing whether a debt is dischargeable, whether their debt is going to be extinguished by the discharge order in the court, then if that were to happen, they're just going to go ahead and file a motion with the court and say, hey, we need the judge here to take a look at this. We think there might be something fraudulent involved, or we think this debt is just non-dischargeable for whatever reason.
And I wasn't sure if they could contest anything.
That, I think they can contest stuff, but I think they would probably go directly to the judge in the court, because the trustee's role in this is looking at the debtor's finances to see if there's any sort of asset of the bankruptcy estate, because all of the debtor's property goes into that bankruptcy estate when the case is filed, and they're looking for anything that they can turn into cash to pay back the creditors. Now, in every state and under federal law, there are what are called bankruptcy exemptions that protect people's property, or exempt it from garnishment or collection, including the bankruptcy trustee. So if someone owned a $100,000 piece of real estate without a mortgage on it, and there was just one person on the deed, they weren't married, and they had a $100,000 piece of real estate, and they filed for bankruptcy, they could keep the house because there's an exemption in Ohio, I think, of $132,000 or $133,000. So that equity in the home would be protected. But if, for instance, that home was $400,000 or $500,000, the trustee could order the sale of the property and give the $132,000 to the debtor after it was sold, and keep the balance on it after they pay their fees to do it. So, but as far as contesting, generally creditors just go straight. I think they would go straight to the court, because the trustee.
I just wasn't sure.
The trustee is not a judge. They're looking for the best interest of the creditor, and if a creditor wants to dispute something that's non-dischargeable, they would have to take it up with the court to get an order on that, and that. So, but yeah, it does happen, just not at the hearing.
My question: if you own a home and you're not behind on the home, but it's other debts that you have that you're trying to get file bankruptcy on.
Right.
What happens to your home? I mean,
Yeah, so that's a good question, right? So, and we can actually, what we can do is we can kind of dive into that, because that'll kind of, we'll take that into, what happens with someone's home, whether they file a 7 or a 13, and we'll also kind of backtrack a bit, and I'll kind of give you some basics of Chapter 13.
okay.
But basically, in a Chapter 7 here, hopefully I'm writing big enough here. But in a Chapter 7, when you have a secured debt like a mortgage, okay, your options are to basically, you could reaffirm, which is you sign a reaffirmation agreement after the bankruptcy case is filed. So if you kind of look on that timeline, you got the date of filing. Usually the creditors will send you, the attorney, the debtor's attorney, or directly to the debtor, a reaffirmation agreement. With the mortgage, it's generally the same terms of whatever was in the mortgage. Someone can reaffirm on a mortgage only if they're current, okay? And I mean, there's some wiggle room there. If someone was 1 or 2 months behind, they're not gonna, not let you reaffirm if you can catch up quickly. So there is some wiggle room there, but basically you would reaffirm on the debt, and you could promise to keep paying it. So that's one option, right? Is reaffirm here. I'm gonna switch this up there. This one's already, let's see here. All right, perfect. So we've got reaffirm on the secured debt, right? So that's an option. So you could reaffirm, and that goes for cars too. You can reaffirm if you're current on it and you want to keep paying on it, you can reaffirm. So for instance, if someone has, let's say, $25,000 worth of credit card debt, they've got a home mortgage that's $100,000, and they have the house is valued at $150,000, right? Well, that $50,000 worth of equity is protected by the homestead exemption in Ohio, right? So if they were to file, as long as they're current, they can keep the house. In fact, you don't necessarily even have to reaffirm. You could just keep making payments if you like. If the debtor wants to just keep making payments, and there's pros and cons to that, and that's something that definitely is a case-by-case basis, but you can keep a property without reaffirming so long as you're current and keep making payments. But there's pros and cons to that. Another option with the house is basically, if someone is behind and they just don't want it anymore, they could just surrender it. And the way the mortgage company would get the property back kind of varies, right? So if there was a foreclosure, sometimes they'll start the foreclosure back up. One option that I find very useful for some of my clients is doing what's called a deed in lieu of foreclosure, where if they want to surrender the property and they just want to give it back, and the mortgage company is okay with that, they can literally deed it back to the mortgage company, so the mortgage company doesn't have to go through all the trouble of doing a foreclosure, and it also allows the debtor to vacate the home kind of on their own terms, So, but there's definitely a lot of issues that can spring up there if there's a foreclosure and sheriff sale dates, because once the property is sold at a sheriff sale date, essentially the person who owns the property doesn't own it anymore, and if they're still living there, they can basically be evicted within 72 hours. So if you can do a deed in lieu of foreclosure, it relieves some of that stress that maybe clients or debtors would see, trying to figure out when can I vacate this property and not worry about just being basically all of their stuff put out to the curb. So, but those are kind of the general options in a Chapter 7 on what to do with keeping the property, So
Does that include vehicles as well?
Yeah, vehicles is a little different. There's kind of a third option with it. So you got the reaffirm, and then you can surrender it, So if someone's severely underwater on their car, or they're having a lot of mechanical problems with the vehicle, or there's a high interest rate on the loan, they can surrender the vehicle and not be liable on any of it. No matter what they can auction the vehicle for, they won't be liable on any of the loan. They can also reaffirm, but generally they have to reaffirm under the same terms. So if someone has poor terms on their financing, usually that there's some wiggle room to negotiate, but not many creditors do that. But so you could reaffirm, but you're basically making a promise to keep paying on it. Now with a reaffirmation agreement, there's a certain amount of time you can cancel. It's not a lot of time. It's 60 days from when the reaffirmation agreement's filed with the court or the time that you receive the discharge order in the Chapter 7. Okay, so there's not a lot of time. So if you reaffirm and that cancellation time and the debtor doesn't rescind the reaffirmation agreement, then what you have is you basically have a new promise to pay that debt, and the debtor's on the hook for it. So if the car were to break down 6 months or a year later and it's only worth $1,000, but that person owes $10,000 on it, well, they've signed a reaffirmation agreement and they could be liable on it. So it's very important that someone seeks legal advice in that situation so that they don't reaffirm on something that was maybe part of the cause of them going to bankruptcy in the beginning, and because then you're kind of maybe perpetuating the problem after the bankruptcy filing. So that's something to look at. With kind of backtracking to Chapter 13, Chapter 13 is basically a repayment plan over 3 to 5 years. And depending on the length of time that the person is in the Chapter 13, it is based off of what they need to pay off, and also the means test, whether or not they're over or under median, and that is kind of a complex thing that someone, generally you want to have an attorney look at that, but in general terms, Chapter 13 is 3 to 5 years long. The advantages to a Chapter 13, you can, if the debtor can afford it, they can pay off taxes that would otherwise be non-dischargeable in a Chapter 7. They can spread out those payments. It's one monthly payment. They can catch up on taxes. They can catch up on car payments, catch up on mortgage payments, and it spreads it out over 3 to 5 years into one monthly payment that is usually deducted every paycheck. A fraction of the monthly payment is deducted from that. So it's basically like a consolidation of all the debtor's debts into one payment. And the advantage to that is at the end of the Chapter 13, they still get the advantage of the automatic stay, so they can stop a sheriff's sale. So if someone files today and there's a sheriff's sale tomorrow, and they have a plan that will pay back that arrearage, they can literally save their house, within 12 hours of it being sold. I mean, they could save, it's a very powerful thing. They could save it right up until the time it's sold. As long as they can get that notice to the sheriff to pull the sheriff's sale, they can save their house right up to the last minute. So those are some of the advantages to Chapter 13, and at the end of it, there's a discharge order. There is a difference in the discharge order from a 7 to a 13, and I kind of don't want to dive into specifics on it, but one thing that's important is you do get a similar discharge to a 7 at the end. It's similar, but it's definitely not exact. And the advantage to that can be if someone is paying back a monthly payment per month, and they're paying their mortgage and catching up on their arrearage, there might be only a small fraction of that payment that's going to their unsecured creditors. Unsecured creditors would be like credit cards, medical bills, payday loans, that sort of thing. And there's a percentage that's going to it. So if that $100 gets paid into it over 60 months to those creditors, that's about $6,000 over 60 months, right? If that person owes $100,000 in unsecured debt, then they are only paying 6 cents on the dollar, because when the discharge order is entered at the end of the plan, it'll wipe out the other 94% of dischargeable debt. And the other money that from the monthly payment would be used to hopefully catch up on the taxes, catch up on the arrearage, and it can work that way to catch people up. And it can save people pennies on the dollar. So someone might have the weight of unsecured credit cards, that sort of thing, but they're behind on their house payment, yet they want to keep their house. Chapter 7 wouldn't really be an option if they want to do that. If the arrearage is sizable, if it's 1 or 2 months, that's one thing. But if it's someone's behind several months or more, then really the only way to catch up is either to come up with the money lump sum or to do a Chapter 13 where it's put into the plan that the arrearage is going to be paid back over the 3 to 5 years. And the debtor would also be able to take advantage of the discharge order at the end to hopefully save money on what they would have, on what they pay back to the unsecureds. So, go ahead.
Does interest come into play?
Yeah, so that's a good point. There is generally there's no interest paid to the unsecured creditors. There's no interest on the arrearage as well. That's kind of generally speaking. There might be some kind of fine points on that, but generally to the unsecureds, there's no interest. On the arrearage, there's no interest. Obviously, the interest is rolled into the mortgage payment. So when someone makes a monthly mortgage payment, part of that is going towards interest. So that's all still there, but there's not an additional interest that's charged on the arrearage. It's only, but if there's interest that's been accrued up until the time of filing, I believe the creditor could ask for that, ask to be paid that, but anything that's accrued afterwards, there's not going to be ongoing interest that's going to be on the arrearage until it's paid off or anything like that.
So follow up,
Yeah.
because I'm thinking, let's say it's $20,000 arrearage
Mhm.
on a mortgage. That's a car payment. That's a car. Okay?
Right.
What makes a car payment expensive a lot of times is the interest.
Mhm.
So actually, a $20,000 arrearage could be pretty affordable over.
Yeah, so because it stops that, you're right.
Am I thinking correctly?
Yeah, with that,
Okay,
but
that's
generally,
not black and white,
but,
I
yeah,
realize.
but generally with the arrearage, the mortgage company may not be, they may be charging late fees and that sort of thing.
Right.
But with the car payment, if you alter the terms of a car payment, then you would have to pay the interest on that. So if the car payment was supposed to be paid in 6 years, right? But I'm just saying, but if it's supposed to be paid in 6 years, and the debtor says, "Hey, I can pay it off in 3 years because I want my plan to end then,"
Right.
well, then they have to pay whatever the market rate interest is. But usually, the person could actually be lowering the interest because generally, whatever the market interest is now, like around 5%. But if the person has a 10 or 15 or more percentage point car loan, then they could reduce that, right? So there's some advantages, and there's some other advantages with vehicles too. In a 7 or 13, I think we kind of skipped one thing, was redeeming the vehicle for the market value of the car, and that's an option that you have only in 7, where if the vehicle is only worth $5,000, but the person owes $20,000 on it, then if you can prove that that's the actual valuation of it, then you can get a court order to allow the debtor to pay the creditor $5,000. So the debtor would either have to come up with that lump sum, or there's some financing companies out there that would offer a $5,000 loan. But that's the kind of the third option that we were talking, that I kind of mentioned, and it's called it's redeem.
But that's only for a car.
Yeah, I mean, the mortgage company, I believe you'd have to just pay it's kind of, you'd have to either pay the full term on it, or keep making the monthly payment. Yeah.
So a surrender, if you have a car and you surrender the car because it's a limit, and they auction it off, but they didn't pay the whole amount of the loan for the car, then what happens to the balance?
Yeah, the balance is wiped clean.
Right.
So any sort of, they call them like automobile loan deficiencies, whether the car was repossessed afterwards or it was surrendered, or if there's any sort of deficiency, once it's sold, it's unsecured, it's dischargeable, and the person is not liable. The only time you would be liable on the car is if you want to keep it, and that's either reaffirming on substantially the same terms or redeeming the vehicle.
But then what if you get discharged and say 2 years go by, are you allowed to sell the car?
Yeah, the car is always, if someone wants to keep the vehicle, whether through reaffirmation or redemption of the vehicle,
And then you get discharged from Chapter 7, and then say 2 years passes, are you
Yeah.
able to sell the car?
the debtor is the owner of the vehicle until they're taken off the title, either by surrendering it. So that person's liable for the insurance on it, whatever to keep it in shape. So if the person redeems it and pays off the loan, or if there's a small balance and they can sell it for more than what it's worth, the debtor's, entitled to do that after, the discharge. That's totally fine. I mean, it's their car. Same thing for the house. If someone's, reaffirmed on the house, even if they don't reaffirm, but they're current on their mortgage and the discharge passed and they want to, sell the house and they can, maybe break even or make some money on it, that's fine. It's still their house until they sell it or it's transferred back to the mortgage company. So there's, it's their property once the trustee, once it's discharged and the trustees, not going after the house because there's exemptions covering it. If someone wants to sell it down the road, several months down the road, I don't really foresee an issue with that. So, but that's kind of the thing with the 7, with the 13. There's also some other advantages with the house. So, one thing you can do over here, one last thing is if you have judgment liens against the property, and judgment lien is when there's a lawsuit, there's a judgment, they file a certificate of judgment here in common pleas court, that attaches the actual judgment to any of the debtor's real estate. So if a debtor owns real estate, there's a judgment lien on it. So if that debtor went to sell it, the title examiners will look at it and say, hey, we have to pay off this judgment lien. So those can actually be removed, generally speaking, in Chapter 7. So that's something important. If someone wants to keep the property, it's very important that they have an attorney that finds the judgment lien, first of all, because oftentimes a debtor might not even be aware that they have a judgment lien against their property, to find that and make sure that it's removed properly by the court, because otherwise 5-10 years down the road, like you said, if they wanted to sell the property, then they're going to get a surprise from the title examiner that says, hey, you know what, there's 3 judgment liens on here and I think we have to pay them back, and then you're going to have a very unhappy person on your hands. So that's kind of one thing with the 7. And kind of jump into the 13 with the mortgages. You can still surrender the property in a 13. The property would be sold, whatever is the unsecured portion after it's auctioned off, whatever is remaining on the mortgage loan deficiency would be lumped in with the credit card. So the person could still surrender if they want. So that's still an option. It's, again, you need to speak to an attorney about whether or not you want to do the surrender before filing or afterwards, and because there's some issues that could arise there. But that's something that can be done in the 13, is to surrender the real estate. The person could relocate to an apartment, file bankruptcy on it, and kind of lump in the mortgage arrearage with all their unsecured debt, medical bills, credit cards. So they can do that. The other option is if they're behind on the mortgage, they can catch up on that over the 3 to 5 years. So there's an advantage to that. They can also remove second mortgages too. So depending on the valuation of the house and the exemptions and that sort of thing, you really need to sit down and kind of do an analysis of it. But it relates to the value of the property and whether or not the person owes more on the first mortgage than what the property is actually worth. So if the property were only to be worth $100,000, but the first mortgage is $110,000, then they have a $35,000 second mortgage. Well, in Chapter 13, you can actually remove that second mortgage of $35,000 and lump it in with the unsecured creditors like credit cards, medical bills, and pay them pennies on the dollar. So it's really powerful for maybe folks who took out equity lines before the mortgage bubble popped about 10 years ago. There's balloon payments that may be due, that sort of thing. So there's things that can be actually avoided, and they'd be lumped in, and they could be paid pennies on the dollar, and that could save someone a lot of money. So that's kind of another thing, is the lien avoidance on it. So I'm going to put down here, pay back arrearage. And the other important thing was remove second mortgage. Okay. Does anyone have kind of any, and I kind of generally went through it. Does anybody have the questions about kind of the mortgage part of things? We kind of switched them back. We were going to do the garnishments first, and just want to make sure we leave time to kind of hit that other topic of today. But we can always come back to it if you have a question that comes up. So that's kind of the general nutshell of it, and I don't think I missed too much, but with how the mortgages are handled in a 7 versus a 13. The other thing I wanted to discuss today was the issue of wage garnishments. So, kind of to boil it down into a nutshell, what are wage garnishments? So that's basically it's a deduction from someone's paycheck, and there's limitations on that dollar amount or percentage amount limitations here in Ohio. But in order to do a garnishment, most creditors have to file a lawsuit. So depending on the amount of the lawsuit, they're going to be either on the first 2 floors of the courthouse where the municipal court is, where the smaller claims are, or if it's a larger claim, it's going to be on the 3rd, 4th, and 5th floors where the common pleas courts are. Okay, so if someone files a lawsuit, depending on the size of what they're asking for from the debtor, they're going to be in either one of those courtrooms or floors. So once they file the lawsuit, the debtor has 28 days to respond. Okay, if they don't respond, the creditor can file what's called a motion for default judgment and say, hey, this debtor owes this, they never replied, we got service on them, and we have a valid debt. They can go to the court and say, we need an order granting default judgment. And so that's what happens if the person doesn't reply. If the person does reply, then they have to defend the lawsuit on some sort of basis, contract laws, argue that the debt isn't valid, or statute of limitations. There's many defenses there that the person could raise, but ultimately it could go to trial. And if that person is found liable on that debt, there would be, again, another judgment against it, but it wouldn't be default. But there would be a judgment found against that person. Either way, if there's ultimately a judgment against the debtor, the creditor can then do what's called a wage notice of wage garnishment, or do a wage garnishment order. And if they know where the debtor works at, they can send that notice there, and then they notify them that, hey, they're going to be taking up to 25% of the debtor's wages. So it's quite a significant number, dollar amount that can be taken out every paycheck until that debt's paid off. There probably would be interest accruing on that too. So sometimes these garnishments, depending on the debtor's paychecks, can go on for months and months and months. And that's kind of the basic of a wage garnishment. Some wage garnishment or some garnishments can occur without the court process. So there's some things that can be done. Usually it's governmental agencies can do that. Child support, taxes, student loans. Those are ways that creditors, the government can go in and go after people's wages. They can also withhold tax refunds. That's a big thing that the government uses to pay themselves back. So the government has kind of more latitude to collect the debt and to do garnishments. There's also the option of actually levying someone's bank account, which is similar to garnishment, but they literally go into someone's bank account. So if they know the account number, so if you pay your landlord with checks or something and they've got it and they can get the order, they can actually go in and levy the tenant's bank account on the eviction if there's damages and collect the money there. So there's options out there that creditors can use to collect these funds. So with respect to bankruptcy, and we can kind of talk about 7 and 13 together on this one about as far as stopping the garnishments, it really boils down to the automatic stay. So if someone gets paid every Friday and they file a bankruptcy case on a Thursday, the bankruptcy attorney needs to notify the creditor's attorney from the lawsuit, get that information out there and say, hey, look, the defendant in this municipal court case is filed for bankruptcy and there's an automatic stay in effect. Any money that's taken afterwards needs to be returned. It's that powerful, the automatic stay is. So the payroll checks have already probably been cut at that time, so the money's going out the door, but eventually that money will be returned. So that's just a really important thing. You can get the money back. As far as getting the money back prior to filing, that's a kind of a murkier area. So there are some things a bankruptcy attorney can do to collect that money back, and it really involves exempting wages, but really the max that can be recovered, generally speaking, is about $1,250, and that's using exemptions to protect it and trying to track it down from creditors' attorneys. But it's definitely far from a guaranteed thing. Sometimes these garnishments are paying back different creditors' attorneys on the same debt. So, the way to stop the wage garnishment is either to pay it off, or you can pay it off sooner outside of bankruptcy, or it is to just file and stop the garnishment on it. In a Chapter 13, same thing. The garnishment's going to stop, and the creditor's attorney from the lawsuit's going to have to file what's called a proof of claim to say, hey, we're still owed this amount. If it's an unsecured debt, which it likely would be, then it would, like all the other credit cards, that sort of thing, it could be paid, pennies on the dollar. So that's kind of the real basics of how garnishments are handled in bankruptcy. So there's some things you can get money back. Definitely, if the money is taken after the case is filed, it should be refunded. I usually say 4 to 6 weeks. And there is a chance to collect the money that's taken prior to filing. So does anyone have any questions about garnishments or?
So this all has to do with then the filing of the bankruptcy after there have been judgments or efforts by the creditors to claim what they're after. So if somebody thinks I'm in too deep, I need to go ahead and file bankruptcy, so then they're accessing the law at that point to protect themselves as much as they can.
Right, so that's how they're protecting themselves. So the automatic stay protects them from any further collection attempts. So once the case is filed, whether it's a 7 or 13, the debtor should get an automatic stay. Now there's some ways people cannot get an automatic stay if they're repeat filers. So if someone's been filing a lot of cases, they may not get the benefit of the automatic stay, but if they haven't, and the vast majority of people who file are going to get the benefit of the automatic stay, and that's going to protect them from those collections moving forward. The creditor has to, in order for them to start garnishing, most creditors, and again it depends on the type of debt, but most, if we're talking medical bills or credit cards or payday loans, just general unsecured debt, or an automobile loan deficiency, they're going to have to go through the local court system, serve that person, the debtor, the lawsuit, give them 4 weeks to respond. If they don't respond, they can move for default judgment. If they do respond, then they're going to have to go before the court and determine if the debtor is really liable for the debt. They can try to defend it there. But ultimately, if there's a judgment or a verdict in favor of the creditor saying that that debt is actually owed, then from there the creditor can start to move to, like you said, actually collect the debt, using garnishment, using bank levy, that sort of thing. They can start to collect it. And at that point, really the debtor's only option there, or only kind of couple options, is either to let them garnish it, try to pay it back sooner. Maybe they get a tax refund and they can just write a check and pay it off sooner, or they're really ultimately going to have to file for bankruptcy if they can't afford to pay it back, along with other debts, depending on all those factors, what people really need to take into consideration when they file: the amount of debt, the ability to pay it back, the types of debts, what they can get rid of in a bankruptcy. Those are all factors someone really needs to look at before they kind of hit the nuclear option of filing.
So filing either form then of bankruptcy would essentially shift as far as the creditor is concerned, it shifts everything onto an entirely different track. They're much more limited in what their options are, it seems.
For the creditor? Yeah, so if there's a bankruptcy case that's filed, generally the first thing that the creditor needs to do is really file a proof of claim, whether it's a 7 or a 13. And what that says is, hey, the debtor owes me money. We have a valid claim. And if it's a Chapter 7, if there's any assets recovered, if there's anything that the trustee can turn into cash to pay back the creditors, then the creditor that's filed the proof of claim already, they're going to be able to get paid on it, right? Whatever percentage that may be. So, yeah, it kind of shifts if there's money there. But if there's not money there or assets there to recover, I would say 9 times out of 10, a Chapter 7 bankruptcy is what's called a no asset filing, meaning there's no money to turn into cash to pay back the creditors. And it's about 9 out of 10. So if that were the case, they're not going to get paid, really.
What happens to all that money? Like when you file for bankruptcy and you get discharged of all that debt, like where does that money go? Like who pays that back?
So
it just goes into a black hole somewhere and our government pays it back?
Right, so I don't believe the government pays it back, but what it is the creditors probably just write it off as a loss. That's what I'm assuming. They write off a loss.
So my second question, to kind of piggyback on that, why are these creditors giving people money at high interest rates when people can't pay it back, I guess? They're part of the problem.
Yeah, I mean, in some cases they can be. In some cases, people, they take out debt and, their circumstances change,
Sure.
And someone can take it out at a point in life where they can afford to pay it back, but through job loss, through health issues, they're unable to pay it back. And if that were to, kind of life changes over the years, obviously, and if they're unable to, then that could be part of it. There are, different types of lenders. There's lenders that are kind of what I think you were referring to, maybe subprime lenders that are kind of filling a void for people. People need to be able to have transportation to get to work, so they may not be able to get financing through the dealer financing like Honda or GM Financial or something, and they need to go out and get a subprime lending. But you're right, it can be difficult paying those debts back because they're at 15, 20, 30% interest rates on a car that's already maybe 5 years old when they purchase it, or 5 or 6 years old. By the time they finish paying it off, the car may be 10, 12 years old, and at that point, it probably needs to be replaced. So you're right, it's a tough thing. But as far as the debt, with respect to the one thing you brought up, a good point, is one thing I wanted to mention is that the debt that is wiped out, that is discharged, the debtor does not have to pay taxes on that. So that's really another advantage to bankruptcy. So, for instance, if someone owes one credit card company $10,000, and they reached out to the creditor and they say, hey, I want to settle it for $2,000. So the creditor agrees to it for whatever reason, the credit card company. Well, at the end of that year, that debtor who settled that is going to get what's called a cancellation of debt income, a 1099 for it, that says, hey, you have $8,000 worth of income you need to pay taxes on because you canceled that debt. So if someone files for bankruptcy, they don't have to pay that back. So, but as far as the creditors, I'm not sure. I'm assuming they're writing it off as a loss, and then that probably benefits their taxes, right? So they can write it off and say, hey, we were unable to collect this debt, that sort of thing. So I'm assuming that's kind of where the creditors maybe get some benefit from it, but the debtors get a benefit when they file because they don't have to pay that cancellation of debt income at the end of a Chapter 13 or whatever they're getting rid of. They don't have to pay the taxes on that cancellation of debt income. So that's really an important benefit because if it's 10 or 20% taxes, it can be thousands of dollars depending on how much is being settled.
So the tax cancellation applies also to it's both types.
No, it does not. Cancellation of debt income is not. It's not something that someone has to pay taxes on if they file for bankruptcy and that debt is discharged. What I'm saying is if they don't and they settle it on their own without filing for bankruptcy, they have to pay taxes on whatever amount is canceled. They should receive a 1099.
Are
So
there certain things you can not put on or put on, like a house, if you're current on it,
Mhm.
but yet you need to file bankruptcy? Do you have to list that? on your?
Yeah, so that's a great question too. So that's a question I get often. Hey, I want to keep my house. I'm current on it. I don't want to list it. The law requires that when a debtor files a bankruptcy case, that they have to list all their debts, whether or not they're keeping them. So it just has to be listed. So I get that question if someone has, they might have a small credit card and they say, hey, it's $100. I just want to pay it off. Someone can do that and not list that debt. If the debt's at zero and they don't owe somebody, then obviously they don't have to list it, right? But the issue is if you have an open account, they may still shut it down. There's probably something in the terms and conditions because the credit card company, even though you're at zero, they might do credit report inquiries just to check in on it once a year. If they see that you filed for bankruptcy, they may close the account anyway, even though it wasn't listed because it was at zero at the time of filing. So it varies depending on the bank and the lender and that sort of thing. But what I would tell people is expect the account to be closed even if you don't owe anything. Definitely it's going to be closed if you owe something.
So how soon after you file can you start building your credit back up and potentially open up another card for like emergency purposes or whatever? How soon can that happen?
So the local credit unions are really good about that. I think people can go there and get what's called secured credit cards or cash-backed credit cards. They may, and those get reported to the credit bureaus. So if the person's trying to rebuild their credit and they know they spend $200 a month on gas, they could put $200 on that secured credit card, use it for that the whole month, and then the beginning of next month, fill it back up, right? So there's some things there that, that's one option that someone can do. Going back to the Chapter 7, if you're reaffirming, let's say on a car or a house, the mortgage company will then take that loan out of bankruptcy. So it won't be reported on the credit bureau as in bankruptcy. So the debtor will get the benefit of it being reported that it's back in repayment and current. So that's a good option. Exactly. Yeah, it'll help build the credit score. And what I've seen is that oftentimes people bounce back probably quicker from filing bankruptcy than if they were to just try to or try to slog their way through it for years, because if they get behind or if the accounts are running very high, the credit score is going to keep going down. But if they can kind of curtail that and file and then do some things like we were just discussing about rebuilding their credit, then I think they can bounce back quicker and kind of get a higher credit score quicker.
Does it, when you file, does it really hit your credit score?
It's not good for your credit, right? So it says it stays on your credit report for 10 years. It's on there for 10 years.
It is 10 years?
Yeah, it's 10 years on there. Chapter 7, you can only file once every 8 years. It varies if you're trying to do a 7 then a 13 or vice versa. There's different time limits on that. But the big one is you can't do the fresh start bankruptcy, but between 8 years, and that's filing the filing date.
Okay, if you do a 7, your house is current.
Mm-hmm.
How long do you have to wait to refinance to make your interest payments lower or pay your house off quicker?
So if someone files and they're current on it and they file, generally the person's probably just going to keep making payments. If they need to modify that loan, most creditors will not let you modify a mortgage unless you've reaffirmed on it, because technically the mortgage is still going to be reported as in bankruptcy unless it's reaffirmed. So most creditors, from what I've seen, they want someone to reaffirm before they'll modify the loan. Now, the debtor can still go out because they own the property. If they can go out to another lender, they could possibly refinance the house. So if they qualify for a refinance mortgage, they can go to another lender and refinance it and get out from the other mortgage. They can do that, and then obviously that would be reported. But that needs to be, that the debtor needs to be able to qualify for that. And depending on whatever program they're using to refund, whatever mortgage program, there's probably time limits on between filing and when they can take out a new mortgage and that sort of thing. And that's really a kind of a case-by-case basis, and something that would probably be best answered by like a mortgage loan officer or going to a mortgage lender, and they would be able to kind of tell you when you can kind of refinance or when you can even take out a new mortgage if someone's filed and wanted to buy a house.
Should you refinance before the bankruptcy, or?
If they want to do a loan modification,
Yes.
I mean, it's kind of 6 of one, 1/2 dozen of the other. If the person knows they're going to keep the property and they're going to reaffirm, then they can do it either way, really. It just depends on how soon they need to file the case. If they're able to do the loan modification and get it done before filing, then that's fine. They'll just, the payment might be lower, or it might allow, sometimes the mortgage companies will take the arrearage and throw it onto the back of the mortgage and do it, do a loan modification. Or the other way is to just file the bankruptcy, reaffirm, and then reach out to the mortgage company about doing a loan modification then, So, but if they're modifying because they're trying to catch up on an arrearage, I would recommend that be done prior to filing bankruptcy. Just so the debtor knows where they stand, because at that point they know that it's been essentially modified, that the arrearage, essentially there's no arrearage because the arrearage has been put on the back of the loan and it's extended out the mortgage maybe for another several years or whatever, and at least the debtor knows going into the bankruptcy, okay, well, I don't have to worry about them maybe not allowing me to modify or whatever, or even reaffirm, because the person might not be able to even reaffirm if they've got a significant arrearage. But if they can modify it before filing, then they'll be better off, right? So they'll know how, they'll know kind of the lay of the landscape before filing.
Okay, it sounds like most people would then be better off to, even though they may feel desperate in a situation where they feel like I have no choice, I have to hurry up and file bankruptcy. It sounds like you're saying that it would really behoove them to do their research in advance and still plan, despite feeling like their back might be against the wall.
With filing, yeah, I mean,
With regard to, their like you said, and perhaps reworking some things before.
Yeah, I think someone needs to really talk to a bankruptcy attorney if they're if they're thinking about filing regardless, because you really need to sit down with someone, sit down with a lawyer and go through the options and qualifying, and there are a lot of issues to consider, like you mentioned, and also just with timing the bankruptcy of when to file, when's the best time to file, when does the person qualify, and that can literally be the difference between filing in 1 month and waiting 1 month, or waiting 3 months, or someone can qualify this month but not qualify the next month, based off of the means test, because there's a 6-month look back period. So if someone's been out of work but then all of a sudden they're starting a job, it might make sense for them to file before waiting 6 months and all their income is on. There's just things to take into consideration about timing. It's really important to talk to somebody that can give you advice on it, on when to file and what the bankruptcy case can actually even do, what it can get rid of, and some of the finer things, finer details of removing mortgages or removing liens, and different ways to save money in the bankruptcy case. It's really important because it can get complicated very quickly.
On chapter 13 in the repayment
Okay.
timeframe, what happens is, let's say you're 2 years in, 3 years in, whatever, and miss a payment.
Mhm.
What happens?
So you can hopefully the person has a bankruptcy attorney that they can call up and say, hey, you remember me? You filed my case 3 years ago and everything's been going great, but I had to miss work and I couldn't make the payment. You can file what's called a motion to suspend a planned payment, and that'll should be granted with the court. There's usually granted 3 to 4 weeks later. As long as there's a valid reason for it, you can suspend the payments.
That's just for 13?
Yeah, because the 13 is 13 is the repayment, right? Yeah, so that's basically you can suspend it. or you can reduce the plan payment. If the person can only afford to pay a smaller amount, you can reduce it down to that. But if there's a mortgage payment in the 13, you got to at least make that payment.
Right.
Because otherwise, if you suspend the whole payment, then it's like not making that mortgage payment for that month, and that payment's going to have to be made at some point.
So, life happens, so if you're in a repayment plan and something, life changes.
Yeah, someone loses their
and all of a
job or
sudden
something.
You can't afford that payment, that can be modified potentially?
Potentially. So yeah, so if someone loses their job but regains employment where they're making, maybe only working part-time, or they're just making less money, different line of work or something, you can modify the plan. But again, that kind of gets into, you really need to sit down, make sure that the person has an attorney on that, because it needs to look at what needs to be paid. Because if the person is making too little money, if they're making less than what they can even pay back the mortgage,
Right.
then there's a problem. The person can't even make the monthly mortgage payment, let alone make the payment, enough of a payment to catch up on an arrearage, or pay the car, or pay off taxes. So there's a lot of things, depending on what the income is and what's going on, it could really torpedo the plan. And at that point, there could be options though. So the person could consider converting the case to a Chapter 7. They can say, hey, I did my best in the 13, but I lost my income and I just can't do it anymore, and I want to convert it to a 7, and that's a possibility. There's some issues there that could not allow it, depending if they filed other cases prior to filing and that sort of thing. The other thing is you could ask for the case to be dismissed. But if the debtor doesn't make payments into the Chapter 13 plan after a few months, the Chapter 13 trustees are going to probably file to dismiss it anyway and say, hey, you haven't been making payments, and if you can't do a suspension, or if you can't afford it because of work, then it's probably going to be granted then, right?
So what actually happens in that case if someone completely defaults and what?
In 13, yeah, so they could convert to a 7. They could try to dismiss it and refile a Chapter 7. There's some options out there. They could try to modify it if they're making less income but still can afford to pay enough to make the plan feasible. It just kind of depends on if the dollar and cents side of it lines up. If it just really comes down to whether or not there's enough cash flow and money.
And what happens if in the rare case, I would assume that the person just completely gives up, skips town, et cetera? What happens legally to the whole?
Well, it would just probably be dismissed. I mean, I'd imagine it would just be dismissed. So do you have a question?
On your sheets here, it says complete a pre-filing credit counseling course.
Right, yeah, so since 2005, there was it's called, short name of it is BAPSIPA, and it's a bankruptcy act that added the requirement of a pre-filing credit counseling course. And you can do it online, you can do it in person. There's some places around town that offer it in person. Do it online, do it by phone, do it in person. But it needs to be completed within 180 days of the bankruptcy case being filed. Then there's also a second course, a post-filing course or financial management course that needs to be completed.
It's a good thing, I think.
Yeah, so there's some good options out there, and they're basically kind of like budgeting classes, and they analyze people's debts and reasons maybe why they're looking to file, and it kind of just goes through people's finances, and I think it is a good thing, but there's different options depending on what people are comfortable with, but it has to be completed one class before and one class after filing.